Hey guys, welcome to today's video. We've got two sovereign citizens causing chaos in two completely different courts, and the second one is actually an interesting update to a case we've been following. But first, let's head into Judge Shackelford's courtroom, where one sovereign citizen isn't just stumbling through the usual SVIT nonsense. No, he's reading the script off a piece of paper. Off camera, of course. Buckle up, because this one's about to get messy.
All right, Mr. Page, this is 242804, the City of Taylor versus Zachary Page.
And good afternoon, Your Honor. For the record, Matthew Zick for the people.
Okay, and I have a note on here. The people are requesting the case be set for a jury trial, and the defendant wants to fire the MIDC attorney. Is that accurate? Mr. Page, are you asking to represent yourself?
Yes, Your Honor. I'm representing myself.
Okay. Okay, you have a right to represent yourself, but I want to make sure you understand this, Mr. Page. You have a right to do that, okay? But you understand that attorneys go to law school and they study the rules of evidence. And if a person who is not a lawyer wants to proceed in a case, they're held to the same standard. You have to play within the same rules as a lawyer when you represent yourself. Do you understand that?
Yes, ma'am.
Okay, Mr. Page, I want you to see this. This is the Michigan court rules. This book is the rules that govern how we do trials, how evidence is admitted, how questions are asked, how trials proceed. And I'm going to assume you've not studied that book. Do you understand that if you go to trial and you represent yourself, that you will be held to the same standard and will be required to comply with those rules?
I understand.
Okay, is there anything else you want to put on record?
Yes.
All right, go ahead.
I, Zachary Page, lowercase a-h-a-r-y, P-A-G-E, a living man and one of the people of the Constitutional Republic of Michigan, appearing today sui juris. I'm here under special appearance and under duress to address this matter.
Oh, you can definitely tell he's new at this. Not only does he have to read his precious manifesto, but he can't even pronounce the words correctly. It's not sui juris, it's sui juris, Latin for basically crayon cruncher. Watching him butcher it while trying to sound intimidating? Absolutely priceless.
I am the beneficiary of the trust established by the U.S. Constitution and the Michigan Constitution, which operate as trust agreements. Under these trust agreements, public officials act as trustees and are bound by their oaths of office to serve the people, the beneficiaries. Their primary duty is to uphold and protect the inherent and unalienable rights of the people, as mandated by these constitutions.
Okay, all right, Mr. Page.
I have more.
I know, you can submit it in writing. I've heard it all before, sir. If you want to be a sovereign citizen today, that's fine with me. All right, but we're going to get through this court proceeding, and I want you to know you're going to behave at trial. You are bound by the laws of the state of Michigan, and that's how we'll be proceeding. So, sir, as to arraignment, how do you plead? You can plead guilty, you can plead not guilty, or you can stand mute.
Could you repeat
Okay.
the last part, please?
You could stand mute. That means you don't say anything, and I enter a not guilty plea for you. So a guilty, not guilty, or stand mute.
I'm pleading not guilty to this.
Clearly, this is someone who Googled how to get out of jail free last night and is now parroting the very first result he saw, word for word, because a true sovereign citizen, or as they like to call themselves in prison, a sui jurist, would never plead to the charge, and they sure as hell wouldn't stand mute. This guy? He's giving a masterclass in wannabe rebellion, and it's absolutely cringeworthy.
Okay, I'll enter a not guilty plea on your behalf. Sorry, I have to go over a few things with you to make sure you understand them, okay? You're
Yeah.
charged with interference with police authority. There is an allegation that on November 4th of 2024, while traveling southbound Telegraph near Brest Street in the city of Taylor, that you engaged in behavior that obstructed or interfered with police authority. That is the allegation against you. This is a misdemeanor. It is punishable maximum by up to 90 days in jail and a fine of up to $500. Sir, you have the right under the Constitution to have a trial by a jury and to have the assistance of an attorney. And you have a right to an attorney appointed at public expense if you are indigent, meaning you don't have the money to pay for an attorney. And if the offense requires a minimum jail sentence, there is no minimum jail sentence on this case, or the court determines it might sentence you to jail. It's my understanding that you have waived your right to a court-appointed attorney. You've already put that on record, and you intend on representing yourself. You also have a right to a trial. And at that trial, you have the following rights: to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Those are your rights under the United States and Michigan Constitution. Do you understand what I just read to you, sir?
Yeah.
I'm not asking if you agree, I'm asking if you understand. And is that a yes?
Yeah, I understand.
Are you sure you actually understand her? Because Judge Shackelford doesn't look like a bridge, and I'm not sure how you think you're supposed to stand under her. It was in that moment I realized, I know the sovereign citizen arguments better than they do, and just like that, the first video wraps up, with the rest of the hearing being completely uneventful as Judge Shackelford simply issued a new court date. But don't go anywhere. Next up is a case I recently covered out of Thurston County, none other than Michael Valentine, another sovereign citizen ready to test the patience of the courtroom.
So, Mr. Valentine, would you unmute, join us, or if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay, and is that how you'd like me to refer to you?
Yes, ma'am.
Okay, I didn't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about, is we're still pending trial. And you weren't, the pretrial services violation, that's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today.
Cocaine is a hell of a drug.
And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously, the state previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted the bond for that amount, and which I believe he was released on October 29th, and within a month we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time, and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh,
I can hear you. I can.
okay. Yeah, the release conditions that were set were not returned to its original state. The release conditions were only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet, and they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state is being prejudiced and tried to keep me with strict release conditions, even though the charges were dismissed.
You think maybe that's because you refuse to acknowledge Washington state laws and the jurisdiction of this court? Let's get one thing straight. Bail isn't some guaranteed right. It's subjective. It exists within a range, can vary from person to person, and is meant to ensure the system works, not cater to your demands. The Constitution? It only protects against excessive bail under the 8th Amendment. It's there to prevent injustice, not to give you a free pass to snort as much cocaine as you want while waiting trial for a DUI. Reality doesn't bend for ignorance, and the law certainly doesn't.
I'll come back to you, Mr. Valentine, but let me ask that particular question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending, or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything.
We got everything.
For tox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? Or I'm sorry, American
Yes.
National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was in on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. This is my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed.
So
even my bail, they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have.
Okay.
Yes, I have.
So, all right. So you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set, release conditions for that charge, that should be done on that case. But they're 2 separate cases now.
All right.
Does that make sense?
Kind of makes sense, but not really. Here's the deal. Under normal circumstances, it would be logical. Your original charge had you on unrestricted release, and the only reason your pretrial conditions were modified was because of a second charge, which, by the way, was eventually thrown out. So in theory, your original conditions should be reinstated while you wait for trial. Sounds fair, right? But that's only true in a vacuum. Reality checks in when you consider two things. A, the state decided to refile the second charge, which triggered your bond modification, and B, while out on bond, you flagrantly violated your pretrial conditions by continuing to use illicit substances. So even if the second charge is dismissed or even refiled, the court is holding you accountable for your actions while on bond. Let actions have consequences, and the system doesn't reset just because you think it should.
Yep, it does. And there was, all right. I guess I don't agree with you. There was a request to October 28th to change the release conditions, and that was denied. I guess that was me. From the court's docket, that's what I'm reading. And so that was considered already, and that was denied. And now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing I'm going to set this it's going to set everything for that January 14 day. And so that we've got everything together. What time that is, but you either, as I said, it's 10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. So we'll set this hearing. The next hearing will be January 14th at 2:30. It's a pretrial. So, any questions about your obligation there?
Yes. What are the nature and cause of these charges?
Driving under the influence. You're charged with and driving while spending the 3rd degree. The complaints are in the court file.
And what is the criminal jurisdiction like? What's the nature of the causes? Is it under admiralty jurisdiction or common law jurisdiction? No.
Washington State, RCW 4661. Violation of the state law. You're in Thurston County District Court, which has jurisdiction over you, as it's alleged to have occurred in Thurston County.
But I'm asking, what's the nature and cause of the charge? Is it under a common law? Is it under common law or admiralty?
It's under Washington State law.
Don't you have the duty to make the nature and cause clear to me, ma'am?
I have.
Do I not have a right to know the nature of the cause?
Yeah, and I have.
The only reason any of us know what you're being charged with is because the judge stated it, on the record. She laid it out plainly. A DUI from 2021 and a second DUI from 2023 that was filed, dropped, and then refiled. One you haven't even been arraigned on yet. So if you're claiming you were never informed, let me ask the obvious question. How do you think we know? This isn't a mystery, and it's not hidden knowledge. It was explained clearly, officially, and out loud. Denying it after the fact doesn't erase the record. It just makes the argument fall apart in real time.
And you can put it to writing if you think there's something more. A bill of particulars might be something that would be useful to you to send to the prosecuting attorney's office. But
I requested a bill of particulars. I've requested a bill of particulars, and I've requested the case transcript. And I've gotten neither.
Yeah, it's not going to be transferred. There's nowhere to transfer it. You're in the correct jurisdiction. You're in Thurston County District Court.
I said I asked for a case transcript. and a bill of,
Transcript,
yeah,
that's not
case
such a big-
transcript and a bill of particulars, and I still
Okay.
haven't gotten it.
All right, we'll follow that up with the prosecuting attorney for the bill of particulars and then the transcript. That would be from the court if you wanted an audio recording of the proceedings. All right,
Still haven't
so,
made clear the nature and cause of the charges, ma'am.
all right, well, I think I have. So you're to turn yourself in to Thurston County Corrections no later than tomorrow by 3 p.m. or you can post 10,000 cash or bond. We'll have our next hearing January 14th, 2:30. And you stay clean and sober and law abiding, and you're still on pretrial services supervision if you're out of custody and you comply with them.
So is the prosecution under common law or under admiralty?
We're not going to go in circles here. You have
I'm
an
just asking you
obligation to
to, I'm
be.
just asking you,
I
as
understand.
my
I've
right, is it
answered.
not my right to know the nature and cause of the charges?
Yep. I've answered you,
so-
Mr.
so
Valentine.
which one-
I'm not going to go in circles. You're in custody by Friday. Or post 10,000 cash or bond. We'll see you January 14th. That's all for today.
So why can't we go back to the original release conditions?
I've already made that ruling, sir.
And it was a void ruling, it's a void judgment.
So long, Mr. Valentine. We've talked. Be in custody by Friday or post your 10,000 cash or bond. We're done here.
So you're not gonna honor your oath to
We're
uphold
done,
the
Mr.
Constitution?
Valentine. I'm honoring my oath and I've done exactly what I'm to do by state law and constitution.
You haven't made
simply
clear the
disagree.
nature, you haven't
We're
made
done,
clear the
Mr.
nature and cause of
Valentine.
the charges, ma'am.
Please mute Mr. Valentine. I don't want him to say something that would be untoward for him. So we're done, Mr. Valentine. Turn yourself in by Friday or post your bond.
Alright, and that's where this video ends. He's got two actual options on the table. Option 1, pay the $10,000 bond and stay out of jail. Option 2, will turn himself in by 3 p.m. today and deal with the consequences head on. And then there's that mysterious third option, the one that only exists inside Valentine's head. Ignore reality, enjoy a little borrowed freedom, and wait for the police to show up with a bench warrant. Let me know what you think, but if I had to put money on it, he's absolutely choosing option number 3. If you liked the video, hit that like button. If you didn't, hit dislike. Fair enough. Either way, drop a comment below and subscribe with notifications on, because you don't want to miss the next time sovereign citizen fantasy runs headfirst into reality.